Hi there, this is Jonathan Ginsberg. I'd like to talk to you today about something called a trustee motion to dismiss your Chapter 13 case. I'd say at least half the cases that I'm involved in, at some point or another, there's going to be a trustee motion to dismiss. And what this means is that the Chapter 13 trustee is filing a motion asking the court to review some problem and to dismiss the case if it's necessary. A motion to dismiss does not mean that your case has been dismissed. It simply means the trustee has identified a significant problem and wants the case dismissed if that problem is not addressed. And typically what happens is the trustee files the motion, we get it usually a couple of days later, then I usually file a response. It's typically a form response saying that we'll fix the problem, and a hearing date will be scheduled sometime 3 to 5 weeks thereafter. And during that 3 to 5 weeks, we should be able to fix the problem. And typically the problems are going to be one of two things. One is funding, and that is that for some reason your case is not properly funded. And the reason for that could be that your employer is not sending in money, the employer stopped deducting money for some reason, isn't sending it in, there's some sort of problem with funding, or that your payroll deduction started too late. So in other words, your first payment is due right away. I mean, if you get paid every 2 weeks, the first payment is due 2 weeks from the time you file. Sometimes employers take a little while to get the payroll deduction set up in your payroll system, and so it may be a month or 6 weeks before that first payment comes in. You're responsible for making up the difference. And if we file the case and there's a gap there and you fall a month or two behind, you may not even realize it, but you're behind, and the trustee could file a motion to dismiss on that basis. So that's a very common reason. Again, another common reason is a situation where your employer just stops sending money in. I've seen this happen more times than I can count, where a new payroll person comes in, doesn't understand what to do. It's real simple where to send it. They just don't send it in, or they stop withholding for some reason, don't tell anybody. Of course, you'll notice it, but if you don't tell me, I wouldn't know. But you always want to make sure that that money is coming out of your payroll office, and we can certainly check to make sure it's getting to the trustee. So that's one reason why your case might be subject to a motion to dismiss. And of course, the cure there is to pay money, and I'll talk about that in a second. The second reason you may find yourself with a motion to dismiss is a terms problem, and that means that your case is running more than 5 years or 60 months. Chapter 13 cases can run no more than 5 years. If it goes beyond 5 years, then the case is not valid under the law. And so sometimes what happens is we file a case and all the claims at the time the case is approved or confirmed, all the claims have not yet arrived into the case. And if a claim comes in higher than expected, with a higher interest rate claim, for example, or just comes in $2,000 or $3,000 more than we thought, the case may run more than 5 years. And I usually try to catch that early on. I do a review after the bar date, the last day creditors can file claims. I do a review to make sure everything is fitting. But sometimes a creditor will modify its claim 3 or 4 months down the road, or again, just a claim comes in too high. If we catch it early, it's usually a pretty simple fix. Maybe we increase your payment by $20 a month. But if it comes in year 4, that can be a problem, because that means now we're dealing with a very short time frame to fix the problem. And if, let's say, we're running, let's say the case is running 60 months, I'm sorry, 65 months, and to make up that 5 months, we need to somehow find an extra $2,000 or $3,000, and you've only got 12 months left to go. You can see, it's going to cost you several $100s extra per month to cure that within that 5 years, or within the 60-month term. So that can be a problem. I have a couple of times filed a motion to ask the judge to forgive the arrearage if it wasn't my client's fault. Sometimes we just work out a consent deal where you just have to really figure out a way to pay it, and maybe meaning that you're eating bread and water for a couple months to get that fixed, because it's really a pity to lose a case in month 54 or 55, but that can be a problem as well. So those are the two reasons, typically funding and term, that you might find a motion to dismiss in your Chapter 13 case. And there can be other reasons, insurance lapses, things like that, but generally it's going to be because of funding or terms. So it's real important for you as the debtor to make sure that money is coming out of your paycheck every month and it's going to the trustee, that you make it up if it doesn't come in, and that as far as the terms, that we really look at it very realistically, that we take a look at all the claims after the last date that creditors have to file claims, which is basically 60 days after the date of the 341 hearing typically. we look at it very carefully and make sure there's no surprises there, and as long as we catch it early, we can probably fix it without a big deal. If it's later, then we have to look at some creative alternatives. Sometimes even the case has to be dismissed. We have to refile it to deal with that. That's really a bad way to do it, but that has happened a couple times. So that's what a motion to dismiss is. The trustees are almost always willing to negotiate a deal. They don't want to see these cases, especially the ones after confirmation, they don't want to see these cases die. Certainly in year 4 and 4.5 and so forth. So they'll be cooperative as much as they can be. But that's our job. My job is to fix those problems, and your job is to communicate with me and let me know what's going on and to work with me to figure out a solution that you can live with that will satisfy the trustee as well. So that is what I would tell you about trustees' motion to dismiss. Got any questions? Drop me an email, give me a call. This is Jonathan Ginsberg, and we'll talk to you soon.